A worker who was sacked by Aldi after senior management found out that he'd been convicted of sexual assault has won €5,000 for unfair dismissal. A WRC hearing adjudicator concluded that there had been a rush to dismissal after bosses at Aldi discovered or were shown a newspaper report on the man's court case and accused him of failing to disclose his conviction, even though it later emerged that he had told his line manager. The worker, Mohammed Kashif, was a cashier at an Aldi store. He had been allowed to keep working for 8 weeks after receiving a 2-month suspended prison sentence at district court level. He pleaded guilty to sexual assault. He was employed by the supermarket group between November 21 and his termination in February 23. He worked around 35 hours a week on average. He also worked 2 or 3 shifts a month at a fast food restaurant, the WRC was told. The company's legal team submitted that Mr. Kashif had pleaded guilty to a charge of sexual assault of a female colleague at a separate employment in court on December 20th, 2022. The case was covered in the local press, but the report only came to the attention of higher management in February 2023 when Mr. Kashif was suspended on full pay. An area manager said in evidence that she had been provided with a copy of the newspaper article on February the 10th, 2023 by another area manager who asked her to look into it and, if necessary, start a disciplinary process. During a disciplinary process, it was put to the employee, Mr. Kashif, that he had been convicted of a criminal offence and failed to disclose this conviction to his line manager. The WRC heard that Mr. Kashif did indeed confirm the conviction to company investigators during the disciplinary, but he told them that he told his line manager about the conviction the day after he was in court. Company meeting minutes noted that the line manager confirmed Mr. Kashif's account and noted that this was accepted by the parties. Evidence was given that the store manager had not disclosed Mr. Kashif's conviction. Aldi's lawyers argued that his contract of employment provided for summary dismissal for any criminal conviction other than a minor motoring offence, and that he had admitted the conviction. Mr. Kashif's legal team argued that there had to be a connection between misconduct outside the workplace and the needs of an employer's business to justify the nuclear option of dismissal. Adjudicator was Patsy Doyle. She wrote that there had been no regard to Mr. Kashif's unblemished record or the 8 weeks of uneventful service after he disclosed the conviction to his bosses. She found that Aldi was overwhelmed by seeing the newspaper report at a later stage and got lost in its anticipation of harm and reputational damage to the business. She found that there was a rush to dismissal and that this was blighted by the respondents' fear of harm rather than actual harm caused by the print media, where it seems that the respondent was not named, she added. Miss Doyle, Patsy Doyle, concluded that the facts before her were not conclusive proof of substantial grounds for dismissal, which is the requirement, and she found that Aldi had veered outside the band of reasonableness for a reasonable employer. She upheld Mr. Kashif's complaint under the Unfair Dismissals Act 1977, but found that the complainant did bear 50% responsibility for his termination. She awarded him €5,000 in compensation, a sum equivalent to about 2 months' gross wages. Hope you find this video useful. If you do, you might find this one useful as well.